Swayam Prabha. Digital India. Educated India.
We had seen the definition of invention under section 21J. Invention means a new product or process involving an inventive step and capable of industrial application. Now, we can see the three components of what constitute an invention, or the three requirements of an invention, or to put it in another way, the three ingredients of an invention, the ingredients that have to be satisfied for an invention to be patentable, namely novelty, the fact that the product or the process for which a patent is claimed is new, and you will find new mentioned in the definition, and the fact that the product or process should involve an inventive step, that is a second requirement, and third requirement that it should be capable of industrial application. Now, let us look at the first part of the definition, the fact that an invention has to be new. Novelty or newness of an invention. The Act does not define novelty per se, there is no definition of a novelty, but the Act does gives you instances on how you can understand a new invention. We had already mentioned that the definition of new invention under the Act, under section 21L, new invention means any invention or technology. Now, the definition is important, is the fact that though novelty or the fact that newness is not defined under the Act, there is a definition of new invention under the Act. So, we understand this definition, new invention, as defining the new part in section 21J. So, this new is defined by this phrase, new invention, and this we understand because what is contained in this definition is the requirement of novelty. Novelty is conveyed in this definition. Now, let us take a look at this. Means any invention or technology which has not been anticipated. Now, invention has to pertain to a technology, or it could also be an invention per se. Now, we understand invention to pertaining only to technology because in practice patent law has evolved only by granting patents for technology. There is no other field for which patents can be granted. So, if there is no technology or if there is no technical effect produced by an invention, we do not regard that as patentable. So, any invention or technology which has not been anticipated. Now, this is phrase that you need to understand, it is a word that you need to understand. Anticipation is discussed in detail in chapter 6 of the Patents Act, section 29 to 34. There anticipation contains all the exceptions to anticipation. What are the instances that do not amount to anticipation? So, here we understand this statement as something, if an invention or technology has not been anticipated, then it is regarded as new. Now, anticipation can happen in multiple ways. Anticipation can happen by publication in any document, or by use in a country or elsewhere before the date of in a country or elsewhere. Now, so that gives us the standard of anticipation is a global standard, regardless of whether the invention was anticipated in a particular country. As long as it is anticipated in any part of the world, it could still affect the novelty of an invention. Meaning which, if you file a patent application in India, there could be a disclosure by publication in scientific journal in the United States, and even if you assume for a moment that particular journal is not available in India, still the standard of novelty, which is an absolute standard, which takes the novelty requirement is determined by looking at the prior art all over the world, still the invention would stand anticipated. Now, in a moment we will come to what we understand by anticipation. Now, here from this statement we can conclude that anticipation can be broadly by two ways. It can be by publication in a document or use in any country. So, these are the two ways in which an invention can be anticipated. Publication is easy to understand because publication of the invention discloses the invention to the world at large in a verifiable manner. So, that is the advantage of a publication. Publication would record the invention and it is verifiable. Say if it is published in an earlier patent application, then it is there as a record which can be verified, and that earlier patent application could become what we call a prior art for the present application, the application for which a novelty determination is being done. So, publication by a document, any document, means that it is published, which means it is disclosed to the public, or in patent law we use the word made available to the public, and it is in such a way that the publication is in a verifiable manner. So, if someone is filing an application for a particular invention, that application as it discloses an invention can be checked for novelty or for lack of it in a published document which has been published before the date of application. So, the prior art is always the date before which the priority for that particular application accrues. So, publication by any document is an easier way of ascertaining anticipation because published documents allow you to verify whether a document that has a disclosure of an invention actually anticipates a patent application. The second type of anticipation is a bit more difficult to ascertain because use in a country could be use that is unrecorded, could be use that is not documented. So, when the use itself is there, but it is not recorded or documented, then it becomes difficult, though not impossible, to prove anticipation. For instance, under section 13, which is cross referenced here, the examiner has to file a report on novelty, that is whether the invention has been anticipated. So, when the examiner does a report on anticipation, he is essentially looking at databases, which means he is looking at documents that have been published before. If there is a use in the same country in where the examiner is examining the patent, and for a moment let us assume that that use has not been documented, it becomes difficult to prove, which means if the issue of novelty is to be raised, then the issue of novelty will be raised before either a court of law or an appellate body or the patent office in such a manner that the use will now be shown by evidence adduced by a person, because whatever is not recorded or whatever is not documented can still be adduced as evidence provided there is a testimony. So, for instance, if there was use of an invention, then the way in which we will understand that use is by people who have witnessed the use filing an affidavit and swearing a statement that they actually witnessed the use. Now, it is difficult to prove use by an affidavit filed by a person, because that would obviously involve examination of the person, and if somebody is disputing that as a piece of evidence, that person also has to be cross examined. Now, examination, cross examination are legal procedures involved when a person deposes as a witness. So, use which is not documented, though it is relevant for understanding anticipation, it is more difficult or harder to prove than the other aspect of anticipation, which can be proved by publication of any document. So, world over, largely anticipation or the lack of novelty the fact that an invention does not have novelty is proved predominantly by publication of documents. And if you see the report of any of the patent office on anticipation, they would largely rely on documents to show that there is no anticipation. If you look at the report by the PCT preliminary report, the X category which says that the invention is not novel, again they would rely on published documents to say that there is no novelty for the invention. So, novelty under the Act is defined by the definition new invention. This is under section 2(1)(l), and we had seen that anticipation can be by two means, publication and by use. Now, we had also mentioned that it is a global standard, and the fact that it should be before the filing of the patent application with the complete specification. Now, the date that brings us to another important aspect of determining novelty. First, we saw that there is a subject matter category, there has to be an invention or a technology. So, unless the patent pertains to an invention or a technology, then only such subject matters are capable of being patented. For instance, section 3 excludes literary and artistic works. So, the fact that something falls within the domain of copyright law cannot be subject matter of patent. So, it has to be an invention as defined under the Act, or it has to pertain to a field of technology which has not been anticipated by publication. Anticipation is the fact that it has been disclosed before. Now, and when we talk about the fact that the disclosure has happened, there are two kinds of disclosure. So, the first key thing in understanding novelty is that it should pertain to an invention or a technology, that is a subject matter. Second, that it should be disclosed either by a document published in any document or by use, that is the manner of disclosure. The first one was subject matter in anticipation, the second element was the manner of disclosure. It could either be in a document or in a use, and use has to be proved by evidence adduced to demonstrate that use. The third important element of novelty, or the fact that an invention is new, is that it should be the disclosure or the thing that anticipates should have happened before the date of filing the patent application with complete specification. Okay. So, this is the date by which we determine the novelty of an invention. If the disclosure or if the anticipating material happened before the date of filing the patent application with complete specification, then it is at that point we are going to look at the prior art. The prior art for determining novelty will be the prior art before the date of filing the patent application with the complete specification. Now, anticipation is defined here. What do we mean by anticipation? By anticipation, we mean that the subject matter has not fallen in the public domain, or it does not form a part of the state of the art. Now, if it is fallen into the public domain, and if it is not protected by secrecy, and secrecy is something which you will see that there are certain measures, even if it falls within the public domain, it will still be a protected disclosure because there was a breach of certain contractual obligations. So, if it is not protected by secrecy and if it falls into the public domain, we would say that the matter is anticipated, or it does not form a part of the state of the art. Now, if something does not form a part of the state of the art, then it is new. If the subject matter has not fallen into the public domain, then again it is new or it satisfies novelty. So, when we phrase it in the negative, if something has fallen into the public domain, then it lacks novelty, or if something forms a part of the state of the art, it again lacks novelty. So, anticipation is the key ingredient for determining novelty, and anticipation is done, the method by which it is done is either by looking at published documents or by looking at use in a particular country or the world at large. In determining novelty, there are certain steps the patent office or the court would take. The first thing, what we had already mentioned, is contained in the definition itself. The definition states that for the purposes of determining novelty, you should look at the documents or the use before the date of filing the patent application with the complete specification. Now, you may ask, why is it that we cannot look at the date of filing of the provisional application? Because provisional is done before the complete in cases where a provisional is filed. Then why is not a novelty determination done from the date of the provisional? It is difficult to make a novelty determination from the date of the provisional because the provisional does not have a claim. And if you see, all the grounds challenging novelty are attacks on the claim. An instance would be, if you would take section 25(1), you will find that section 25(1) B and C pertain to grounds challenging the novelty of an invention. B states that an invention so far as claimed in any claim has been published before the priority date, and C says the invention so far as claimed in any claim is claimed in a claim of a complete specification published on or after the priority date. Now, invention so far as claimed in any claim of a complete specification means that a pre-requirement for a novelty analysis is that there has to be a claim. So, that is why you find that the definition refers to the date of filing the patent application with the complete specification. So, the novelty analysis requires a date on which the patent application will be analyzed. So, the date of filing the patent application with the complete specification is the date for determining priority. So, this much is clear. The date for determining novelty is the date of filing of the patent application with the complete specification. Now, any document that was published before this date will be relevant for a novelty analysis. Similarly, any use before the date of filing of the patent application with the complete specification will again be useful for determining novelty of an application. It does not mean that just because there is a disclosure that predates the patent application that it would anticipate. Disclosure is one thing and anticipation is another thing. These are two different concepts. Disclosure merely means that something has been disclosed, it has been made available to the public. Anticipation means that the disclosure falls within the ambit of what has been claimed in the complete specification. So, anticipation involves multiple steps. It involves constructing the prior art. The first step will be to construe the prior art or to construct the prior art, and the construction of the prior art is done from the viewpoint of a person skilled in the art. So, the prior art is first identified and it is done from the viewpoint of a person skilled in the art. In explaining new invention, the definition brings out two aspects of what would be new, or the newness of an invention is to be compared with either the public domain, that is one criteria for understanding whether something is new, or what is defined as the state of the art. The public domain is easy to understand because if something is available to the public, then we will understand that as the public domain. Now, public domain does not mean it has to be available freely. So, they could be subscription websites where a piece of disclosure is published, but it is not available to the public unless a person pays a subscription fee. That would still amount to the public domain. The fact that something is behind the wall, behind a paywall, and it requires payment of money will not take it away from the public domain. That would nevertheless be the public domain, but it would still be a protected space. but nevertheless it is the public domain, and the fact that something has to be in the public domain is not equated to something being available free of cost. So, that is a critical point to be noted. The public domain could also include subscription websites or material that has been posted behind a paywall. State of the art means the state of technology rather than the state of art in commerce or business. So, whenever we talk about the state of the art, art refers to the technology. So, when we talk about novelty, or for that matter even inventive step, we are only concerned about the technical features. We are not concerned about any other feature of an invention. There may be some features in an invention which the customers like, or which helps in spreading the word about the invention, or there could be some social features which people find interesting. But when we are talking about an invention, we are specifically looking at the technical features. So, novelty, just like inventive step, is determined using looking at the technical features of the invention. Now, the question of novelty involves when did the prior art disclose the invention, the point at which the disclosure happened, and when did it anticipate, what, which means the document or the use that actually anticipated it, and under what circumstances was it made available to the public. So, three things: one is a when, the second is a what, and the third one under which circumstances it was made available to the public. Now, under which circumstances would include certain circumstances which are exempted from an anticipation analysis or a novelty analysis. Section 29 to 34 lists category of disclosures or circumstances which are excluded for the purpose of an novelty analysis. The definition refers to the subject matter has not fallen in public domain. Now, what constitutes public? Is it a large group of people, or is a disclosure to one person a disclosure to the public? Now, there are case laws which says that in determining novelty analysis, even if the disclosure is made to one person, that would amount to killing the novelty of an invention, which means that even a disclosure made to one person, if the person is not bound by any contract or secrecy obligations, for instance, there was no non-disclosure agreement with that person, or the person was not under the employment of a company where he was bound by the terms and conditions of his employment not to disclose the invention. If such a person, even if he is one person, if a disclosure is made to him, that would amount to a novelty killing disclosure. So, it is not, when we use the word public in public domain, even a disclosure made to one person will be regarded as a disclosure made to the public, and it will be regarded that it was made available to the public. Now, in determining novelty, the general rule is that an invention lacks novelty where there is complete correspondence between all of the technical features of the application and the item of prior art. Now, there has to be a complete match of all the technical features as disclosed in the application and as compared to the prior art. It is not sufficient that just the essential features are common in the prior art and the application. Rather, all the technical features have to be disclosed. So, novelty analysis would require a claim to be mapped exactly in all its technical features onto the prior art. So, the subject matter will not be anticipated if some features in a claim are mapped on to a disclosure in the prior art, whereas there are other technical features which do not have, which are not disclosed in that prior art. Now, what happens when the prior art disclosure affecting novelty is not in a single document? Say there are two different documents and the two different documents disclose all the technical features put together of the application. In other words, the application has a set of technical features which can be mapped to prior art A. It also has a set of other technical features in the claim which can be mapped to prior art B. So, how does a person look at a novelty analysis when the disclosure is in different documents? Now, the rule in determining novelty is that mosaicing or comparing different documents is not permissible for the purposes of determining novelty. So, there must be individual and separate comparison between the claimed invention and the prior art. So, the comparison is going to be individual and it is going to be separate. A person will not be allowed to do a mosaicing. A mosaicing is comparing different documents, reading them together. So, whereas mosaicing is allowed to be done when it is a determination of lack of inventive step, which is the second requirement of patentability. In some cases, you will find that the documents, because it is not permissible to read them together or it is not permissible to mosaic them, the documents will not disclose or will not be, the disclosures in a document cannot prove lack of novelty because the disclosures are in different places. But the same documents could be used for determining lack of inventive step, and in that case mosaicing is permitted. Now, we will look at how that happens when we discuss inventive step. So, when you are looking at a novelty analysis, you would also keep the inventive step analysis at the back of your mind, because the same documents can be used for determining lack of inventive step. So, what distinguishes the novelty requirement from an inventive step requirement is the fact that the invention in an inventive step analysis is seen as whether it was obvious to a person skilled in the art. So, that brings the knowledge of the person skilled in the art, what we call the mental element, which is absent in a novelty analysis. In a novelty analysis, your sole concern is whether the invention as disclosed in the patent application has been anticipated before by publication or by use, and in anticipation you are going to look for a complete matching of the invention in the prior art. So, it does not give the disclosure that you find in the prior art should be a complete disclosure which maps all the technical features that have been claimed in a patent application.